In this video, we're going to cover some of the most commonly asked questions regarding the transition from H1B to a marriage adjustment of status. Let's imagine you're in the US working and you meet a person you fall in love with. You guys make a decision to get married and proceed with a marriage green card. If that sounds like you and you just started looking into this transition, you are likely not even sure where to start, and I'm sure you're also wondering how this transition will impact your current status. In this video, we'll go over some of the most important things to know and consider, plus I will share with you some real timelines from inside our method, this exact same scenario, H1B to marriage adjustment, so you have an idea on how long this process can take for you. Look, we receive a lot of questions from immigrant couples wanting to adjust status through marriage from an H1B visa. So many of these couples have been together for many years, whereas the immigrant spouse entered the US on an F1 many years ago, got a degree, went through OPT, and then H1B, but it's finally time to make it official and get that marriage green card. Now, knowing how this adjustment process will go from this current visa is very important, so you're not constantly stressed out about whether you're jeopardizing your current status and instead are able to focus on other important things in your life, such as your relationship, work, buying a house, and everything in between. Alright, so you're here on H1B and now you're about to get married and it's time to apply for a marriage adjustment of status. Let's start with question number 1. Will a pending marriage green card application affect your current status? Obviously, the question is, am I jeopardizing my current visa by submitting this marriage application? The answer is no. What you need to know is that the USCIS will treat the H1B and marriage green card as two separate processes and statuses which are unrelated. And when it comes to H1B, even a rejection of a marriage green card application generally will not affect your H1B status unless your H1B gets terminated in the meantime, and we will talk about this later in this video, so stay with me. Another question we often get is there a difference if a work visa holder marries a US citizen versus a legal permanent resident? And yes, there is a difference. Let's start with a scenario where you're married to a US citizen. In this case, the US citizen spouse files an I-130 petition and supplemental I-130A form with the USCIS on behalf of their foreign spouse. With this petition, the US citizen is officially asking the government to recognize the bona fide marriage between two spouses, which will be the basis for the grant of a family-based visa. And then from there, the foreign spouse files a marriage green card application, form I-485, to ask the government for legal permanent residency based on that family-based visa. The good news is that because there is no yearly limit on the number of immediate relative visas the government can grant, as it is in the immediate relative visa category, the USCIS allows you to perform both steps simultaneously and file the I-130 and I-485 forms together, which is called concurrent filing. This allows both requests to be processed at the same time, which shortens the application timeline considerably. If you're new to your research and you're still trying to understand how this process works and what goes into it, you can check our video on concurrent filing to learn more. And just a quick note, although we are answering the most commonly asked questions here, if you still aren't sure how something applies to your specific situation, just drop your questions in the comments and we will make sure to address them. Now, if you're married to a legal permanent resident or a green card holder, there are some nuances to this process. You will still file forms I-130 and I-485 in this case, but you now need to look at the visa bulletin. The April 2023 visa bulletin saw a drastic change to the F2A category, which is spouse and unmarried children under age of 21 of US green card holders. Due to an overwhelming number of cases in this category, the final action dates for these applications have lost their current status for the first time in years, since 2019, I believe. Final action dates pertain to applications that have reached the front of the line and can now be processed. Although still able to file, you will not be able to move forward with your green card application until the priority date is current. This change brought about increased wait times for green cards under the F2A category. This makes it all the more imperative for the green card holder spouse to file for naturalization as soon as they're eligible, as there is always a looming danger that the process may drag on past the H1B holder's 6-year time limit to remain in the United States. Now, unfortunately, due to massive tech industry layoffs we've been seeing recently, the question we often get is, can I begin the marriage green card process if I have lost my H1B status? You can if you're married to a US citizen, but you cannot if you're married to a green card holder. If you're married to a US citizen and your H1B status has already expired, you can still file for a marriage green card. This is because the US immigration law allows immediate relatives of US citizens, meaning spouses, minor children, and parents, to adjust to permanent residency by filing Form I-485 even if they're out of status. Keep in mind that this rule does not apply if you have left the United States after being in an unlawful unlawful presence for more than 180 days in the country, or if you have entered the US illegally in the past, which is highly unlikely in your case, but it just had to be mentioned. When it comes to spouses of green card holders, you cannot obtain a marriage green card inside the US if you fail to keep a valid status when you file Form I-485. However, you may be eligible to obtain a marriage green card outside the US through consular processing if you accrued unlawful presence in the US for less than 180 days before leaving the US. Another important question we always get has to do with work permits. Again, it's the transition period that couples are often unsure about. So, can you apply for an EAD card based on your marriage green card application even though you have a valid H1B status? What happens if you use that EAD or that work permit? You have the option to file for work authorization or Form I-765 alongside your Form I-485. This will grant you an EAD card, which is separate work authorization from the one you received with your H1B. Filing for and obtaining an EAD card does not by itself affect your H1B status, and it is often a very good precautionary measure to have in case you lose your H1B work authorization during the long application process, especially if you are already near the 6-year limit. In this case, you would be able to use your EAD work authorization once your H1B work authorization expires. And it's generally a good idea to apply since it takes the USCIS such a long time to process work permits. It is also a big consideration now that you have to pay for your work permit through this marriage process, which is $260 if filing together with Form I-485. By the way, you can gain free access to our mini course where we go over all the required forms, filing fees for each form, etc. It will give you a ton of clarity if you're still researching. Again, you would generally want to apply for your work permit. Otherwise, you might regret not doing so if something happens to your current employment. But you do need to know that if you use your marriage adjustment EAD while you're still on H1B status, for instance, for a second part-time job, whatever, you automatically terminate your H1B status. This really doesn't make too much sense. It's not very logical, but it is the way, so just be mindful of that. And by the way, the same applies to advance parole or travel permit. Filing for and obtaining advance parole does not by itself affect your H1B status, and it is often, again, a good precautionary measure to have in case you lose your H1B travel authorization during the long application process. But if you use your advance parole while you're still in H1B status, meaning you leave the United States and come back as a parolee, you automatically terminate your H1B status. It is important to note that applying for or receiving an advance parole document does not terminate H1B status. Rather, re-entering the United States using the advance parole document is what terminates the H1B visa and makes the visa holder deemed a parolee, and same goes for a work permit. Okay. Another important question we get is, how long will it take to transition from a work visa to a marriage green card if applying from inside the US? Our recent member went from H1B to marriage adjustment in only 62 days. And check that, it happened despite a phony RFE. In this case, the USCIS issued a request for evidence on Form I-864 claiming that the sponsor's spouse with an income of well over $60,000 did not qualify to be a sponsor. As a reminder, the current requirement is to make $25,550 for a household of 2. All you need to know is that the USCIS loves issuing erroneous RFEs on Form I-864, basically delaying cases. That is why it's impossible to accurately predict your timeline since there are so many factors to consider, but currently, spouses of US citizens should plan for at least 12 months. Inside our marriage immigration method, on average, it takes 5.5 months to get through this process, but it can easily take up to 2 years. Speaking of which, if you want to handle your marriage adjustment of status, removal of conditions, and naturalization like a pro, I invite you to apply to our marriage immigration method, where we guide professional couples like you through the entire immigration journey. We just give you a peace of mind and ensure that you handle this right and on the first try. Alright, final comment about the fees. The current fees that you pay directly to the USCIS for the whole process, including both work and travel permits, are $3,005 or $2,375 if you're not filing for a travel permit. Again, for detailed breakdown on this, you can access our mini course in the description below, since the fees also change depending on whether you're filing I-130 online or on paper, all of that stuff. Otherwise, that's it for this video. Give this video a like and we will see you next week.